What to expect at a jury trial in Washington State. If you're scheduled for a jury trial, if you're charged with a crime or someone you know is, what should we expect? What are the pluses and minuses, and where is a case won or lost? If you're interested in the state of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like it, please subscribe. More people get to see it. More people get the help they need. Now in Washington State, if we're charged with the crime, we have a right to a jury trial unless we are a juvenile defendant. And juvenile defendants are called respondents. In juvenile court, there is no right to a jury trial. A judge decides guilt or innocence. So in Washington State, a jury trial for a non-felony, you get 6 jurors that have to be impaneled and sworn in. And for a felony, it's typically 12 jurors. Now, there might be a few more that are alternates, but it's 6 for non-felonies, 12 for felonies. And so this is what to expect at a jury trial. Now, number one, if you're charged with a crime, you're going to have a jury trial date set typically. There's going to be your arraignment where you say not guilty. They're going to set a pre-trial. They might call it different things. And then they're going to set a jury trial. And you'll see that jury trial date is set within 90 days of the date of your arraignment. You know, oh my God, I have trial this quickly. No, you don't. Almost always that trial gets moved a bunch of times as so many things have to happen before a trial can happen. Negotiation, right? So hopefully it doesn't happen. Interviewing of witnesses, police officers, alleged victims, securing of experts, looking at the scene, photographs, body cam, you name it. So those jury trial dates get moved. Now let's say that you've talked to your attorney and this case is going to trial. So what should you expect? So the first thing you should expect is that your attorney has interviewed the witnesses and you're going to have some idea about what they're going to say before they show up in court to testify, either your attorney or your attorney's investigator or a combination of both. Now, you're not going to typically be at this interview. That's not the role of the client. It's the role of the attorney or the attorney's investigator or both. And so the attorney will then be preparing how they want to question these witnesses, and they're going to be taking into account who the witnesses might be for the most important part of jury trial, according to some, which is jury selection. So on your trial day, you're going to show up to court, and there's going to be some arguments between the attorneys about what's the order of things, how things are going to go, but all trials start with jury selection, and we would call that voir dire. Some people call it voir dire. I say voir dire, but it basically means to find the truth, something like that. That's where we're supposed to learn whether or not people in the jury can be unbiased and they can follow the law. So how do jurors get selected for court? Well, typically speaking in Washington State, it's voter registration, stuff like that, and they will get sent summons to appear in court, and then if some people will get out of it, they don't show up. But basically, so many jurors show up, and then for your trial, if you need 6 jurors, maybe they pick 25 people to come into the courtroom and have a seat where your attorneys now get to ask them questions either individually or in mass all at once. And what your attorney there is trying to do is trying to find if there's any bias. And it's hard, and your attorney might ask some strange questions, and the attorney might even make you feel a little bit insulted, but here's why. Think about it. Let's say that I had a client that was heavily tattooed, including a teardrop tattoo, and I don't have anything against tattoos, but people that have face tattoos and things like that, sometimes society, people in the jury who aren't into that type of thing might think negatively about that type of person. And so if we were to just ask a juror, hey, how do you feel about people that have face tattoos? And they want to look good, right, in front of the jury. Oh, I'm fine with that, no big deal. But wouldn't we want to know if someone's really scared by that, or they're biased, or they think negatively about that type of thing? So your attorney might have to give to get. In that situation, your attorney might say, hey, when I took this case with Mr. Smith, I noticed he has tattoos all over his face, a teardrop, stuff like that, and that scared me a little bit, right? It's not something I've ever seen, and I see people in prison like that, and, it made me take it back. I thought, I was a little bit more likely to think that Mr. Smith maybe did something wrong. Does Does anyone feel like I do? And you might notice that if I'm giving up a supposed bias, then it's more okay for a juror to give up a supposed bias back. Because the purpose of voir dire isn't to make everyone feel good. It's trying to get to the truth of what they actually think. Because if that juror is biased against Mr. Smith because how he looks, I need to get rid of that juror. Because Mr. Smith is not going to get a fair trial. So basically, through this jury selection process, each side gets some automatic strikes, preemptory strikes, where you can remove someone without a reason. And then if someone would raise their hand and say, yeah, I can't be fair to people that have face tattoos, well, then they'd say, Your Honor, I'm asking to excuse that juror for cause. And if that person is excused for cause, now I say my preemptory for someone I just don't like. So once the jury is selected, then the jury is going to get instructed on what the law is. And you as the defendant, you're just going to be sitting there listening, and the judge typically is going to read the law to the jury in some portions of it, not necessarily everything, but some of it, about how they're to behave, about what evidence is, and we can't deliberate until all the evidence is in, and we can't talk to each other, and those type of things. And they're also going to mention that what comes next is not evidence, and that's going to be opening statements. So typically the government in Washington State goes first. Opening statements is where the government is going to say what they expect the evidence to show. I expect the evidence will show this, this, and the other thing. They're not supposed to argue. Then your defense can give an opening right then, or they can reserve opening until their half of the case. Typically, defense attorneys, unless there's a very good reason not to, will give their opening at that time and not hold their opening until the state rests. And that's because we don't want to have the jury just hear one side of things for days and not get some idea of where the defense might go. Now we're through jury selection, we've got the law established, we've done our openings. Now what happens? Now the state puts on their case. The state goes first. They call whatever witnesses they want, whatever order they want, and then every time a witness testifies on direct by the person offering them, then the defense or the other side gets to cross-examine them. And in cross-examination, all you need to know is that whoever's doing the cross-examination basically can lead the witness. That means put words in their mouth. If the prosecutor wanted to know what color the stoplight is on direct, they're not supposed to lead. They have to say, what color was the light? They'll say red, yellow, or green, or I don't know. On defense, if that's an issue, if we're crossing it, the light was green. We've led them to tell them the light was green, and that's sort of the simple way to think about the difference. So the state puts in all their witnesses. Now the defense will typically make a motion to dismiss once the state rests. We'll say, Judge, we're making a motion to dismiss because no jury could possibly find my client guilty because they've missed this element, they haven't proven X, Y, or Z beyond a reasonable doubt, those type of things. And once in a blue moon, we get a lightning strike and a judge agrees and they dismiss the case. Usually the judge says, no, I have to view the evidence in the light most favorable to the state. And I think a rational jury, when viewing the light most favorable to the state, they could find the defendant guilty. And this is done outside the presence of the jury, obviously. Now the defense has a choice. They can put on a case or they can rest. Now remember, the state has the burden to prove the case beyond a reasonable doubt, whatever that means. Okay, it means there's a legal standard. I'm not going to read it here because the legal standard doesn't really matter. It's whatever the jury thinks it means is what matters, right? What we can get away with in our arguments. So if the defense can just rest and say, I'm not putting on a case, and then just argue that the prosecution didn't meet their burden by showing every element beyond a reasonable doubt. Some defense attorneys argue that's the best way to win a case because then the jury's not looking at the holes in the defense case. Also, they're only looking at the holes in the government case. And if you do present a case, well, then your attorney may call witnesses, and then it's up to the defendant whether or not the defendant testifies. If the defendant does not testify, the silence cannot be used against the defendant. The case would get reversed if the prosecutor did that. Well, we know Mr. Smith is guilty because he didn't get up in here and talk to you. You really would like to have heard from him, wouldn't you? That's reversed, right? We can't use their silence against them. However, let's say I'm the attorney and I don't want Mr. Smith to testify. Hey, you're terrible. I don't want you to testify. I'll tackle you before you testify. He still gets to decide, right? I can't stop him from testifying. And also, an attorney can't suborn perjury. We can't support a client testifying to something that we know for a fact is not true. So the defendant testifies or not, the defendant testifies. The problem is now the prosecutor is going to tear them apart on cross-examination. Even little things can be made to look like big things, because remember, in many attorneys' opinions, once the defendant testifies, burden of proof is out the window. A jury has a hard time even imagining what beyond a reasonable doubt means, even though we tell them. But once a defendant testifies, they just go, do I believe him or not? Right? Do I like him or not? And just as a human that sort of, I don't like him, guilty. Right? Most people can't sort of separate out intellectually that feeling that they get versus what the law is. And so many times defense attorneys will beg their clients not to testify. Some cases you have to, self-defense, things like that. Sometimes you have to establish something to be able to assert a defense. Talk to your attorney about that. So everybody's done testifying. Prosecutor can put on a rebuttal case if they want, rebut what the defense said, a couple more witnesses. Now we get to the real fight about the law. Everybody's fighting about the jury instructions, right? The defense attorneys are going to fight about the jury instructions. What is this one? Do we want this one or that one? And this is outside the presence of a jury. Now the jury is called back in. Typically, they're read the jury instructions either before or after closing. Depends on how the judge wants to do it. And then there's closing arguments. So closing arguments are different than opening. Opening is, we don't get to argue. Closing, we get to argue. Well, the state's case is terrible because this officer didn't do appropriate research. They didn't talk to this witness or that witness, and you heard the officer lie on the stand about this. Prosecution says the opposite. Prosecution goes first, defense goes second, and Washington State prosecutor gets to end with the rebuttal at the end. Now, finally, the case is submitted to the jury. Now the jury has to agree or not. So once the case is submitted to a jury, in Washington State, it has to be unanimous in a criminal trial. It has to be unanimous guilty or unanimous not guilty. Not anonymous, unanimous. That means everyone agrees. And if they can't agree and the jury is hopelessly deadlocked, eventually the court can declare a mistrial. And it's usually a mistrial without prejudice to refiling. If misconduct of the government caused the mistrial, then the defense would say mistrial with prejudice, which means you can't refile it, you're done. But usually, given that judges like to get reelected, and also the law is pretty favorable to the state and not to the defense, it's usually going to be a mistrial without prejudice. And now what we think about it is the defense at that point is still not guilty or walking away. And now it's up to the state to decide whether or not they retry the person. Let's say the bad thing happens if your defense attorney, your client's found guilty. Well, will sentencing happen right then? Typically not. Typically it's going to get set over for sentencing. Some types of offenses you might have to be taken into custody right then, most not. And if it's not guilty, well, the state cannot retry it, right? If it's not guilty and there's a bunch of errors by the judge and the state's mad about all the rulings that went against them, they cannot appeal on not guilty. One of the first times I lost a case as a prosecutor, the judge gave a really bizarre ruling saying, well, you're guilty, but I'm going to find you not guilty. And I came back to the 24 years old, and I came back, I'm so mad, and I go to my supervisor, and they're like, I was still in law school back then, and it's like, Lance, you can't appeal on not guilty. I'm like, what? How can I not appeal? How can I should be able to appeal all these errors. So basically, the defense attorney can push the edge of things in a trial, because if we get a not guilty, the state can't do anything about it. If the state pushes the edge and there's a guilty, the defendant does get to appeal for prosecutorial misconduct, legal error, all types of stuff. And so appeal rights only go one way. It's one of the only things that favors the defendant. Not guilty is the ultimate thing that says, I'm walking out of here as far as the criminal charges goes. We just watched the Karen Reed trial, some of us. She got not guilty on pretty much everything. She got a lesser included verdict, right? So there are possible lesser included charges that someone can charge, like the charge with assault 2, they might charge a less, which takes a certain type of injury. They might charge a lesser included offense of assault 4, which doesn't take a certain type of injury. So the jury might find someone not guilty on assault 2, but guilty on assault 4. Sort of what happened in Karen Reed. So, done a lot of talking about what are the steps of a trial. What are the important ones, right? The most important ones are the voir dire. That's where we pick the jury. And the next most important thing is the closing, where we try to put together the entire argument and use everything that happened in the trial. Use that dumb thing the cop said or that dumb thing the witness said and beat it to death, and use, alliteration and drama and harmonics and even mnemonics, right? Even stuff like OJ, if it doesn't fit, you must acquit. That's not evidence, right? But that got to be said in closing. They couldn't say that any other time. And what do I remember from all those years ago? It's one thing I remember. That was a great closing. So hopefully you found this useful. If you're set for a jury trial, wish you the best. Maybe it goes away. A lot of cases go away at trial if witnesses don't show. Sometimes they can still proceed if witnesses don't show. But if you found it useful, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you get a criminal problem in Washington State, feel free to reach out to our firm. If we get on board, we'll listen to what happened. We'll identify a way forward. We will be there for you. Thank you.